There is provision in Queensland to apply to the court after 2 years from the making of a disqualification order to rescind that order and any other order that's running cumulatively alongside it, to enable a driver to obtain a driver's licence and drive again. Under cumulative sentencing rules, and those rules are when orders are made for disqualification, usually for multiple offences, in some circumstances those orders don't run side by side together all at the same time. One only starts to run after the other one's expired. For example, with drink driving attaching to other offences, such as dangerous driving or driving unlicensed, disqualified driving when alcohol is involved at the same time the offences occur. All of those orders for disqualification for each offence run one after the other, and that can result in quite a number of years in real time being served as a disqualified driver. But there is provision after 2 years to apply to have the balance of all those orders rebated, rescinded off the history, enabling you to return to Queensland Transport and obtain a new driver's licence. The basis on which the application is made is to show that you are a fit and proper person in all the circumstances to drive again without having to serve out the full period of time. The circumstances the court will consider are the efforts you've made to rehabilitate. If alcohol was involved, have you addressed your problems with alcohol? Perhaps someone was injured in an accident. What view do they take of you returning to the road early? There may be other factors which led to the offending. It could have resulted from a domestic violence incident. It could have resulted from other offending which attached to drink driving. You need to satisfy the court that you've dealt with all those issues which led to you being disqualified in the first instance. The court would consider all that material, and the police are entitled to be heard. They may oppose it, they may not oppose. They may ask that the order take effect at a latter period of time, not necessarily at the time you apply in court, but perhaps 6 or 12 months later. But usually the courts will consider favourably efforts made to rehabilitate and the need to drive again to become or return to be a productive member of the community, particularly in relation to keeping your job and holding down meaningful employment. It often involves having a driver's licence, and the court's very aware of that. But the onus is certainly on the applicant to show they're fit and proper to return to driving early. The onus is not on the court to have to give that concession. It's a case of showing that you are a fit and proper person to drive again without having to serve out the full cumulative effect of the disqualification orders.